Good evening, everyone. I'd just like to start by acknowledging that this event is taking place on the land of the Wurundjeri people of the Kulin Nation. I pay my respects to their elders, past and present. As this is NAIDOC week and the theme is for our elders, I'd like to acknowledge the work of so many of our elders in the fight for justice since this land was invaded and colonised. Elders such as William Barrick, a leader, advocate and diplomat who worked to win human and legal rights for Aboriginal people, and Auntie Molly Dyer, who was involved in establishing the Australia Aborigines Advancement League and founded the Victorian Aboriginal Childcare Agency. We are the oldest striving culture on earth because that culture is strong. Our elders have always been central to building and maintaining the strength of our people. Sovereignty was never ceded. It always was and it always will be Aboriginal land. Welcome to the Wheeler Centre, everyone, and happy NAIDOC week. I'm Amanda Dunstall. I'm filling in the panel tonight for Narita Waite, who unfortunately is sick. I'm the Deputy CEO of the Victorian Aboriginal Legal Service. It is my third week, so please be kind.
You're going to do fine.
You're doing Hence well. The notes. And I'm a proud Gundi Chamara woman. So let me refer back to my notes. Spaces like this are important, and I want to thank and acknowledge the Wheeler Centre for hosting this event. And of course, tonight we're here to talk about the Koori Courts. So the Koori Courts first began in 2002. They came out of the recommendations of the Royal Commission into Aboriginal Deaths in Custody. It is a really innovative approach to bringing Aboriginal structures, knowledge and culture into the court process to try and improve outcomes for our people. For the last 235 years, the British-based legal system has embedded some of the worst atrocities of colonisation, and still today it has a lot of ways of trapping our people within it. It has been so effective that our people are the most over-incarcerated peoples on earth. The Koori Courts have become an important part of breaking that systemic injustice and the generalisation impacts of incarceration. Certainly at VALS, we hear endlessly from clients and community who want the Koori Courts expanded, and there aren't too many other elements of the legal system that we get that feedback for. We've got a full panel tonight of Aboriginal people who are working in the Koori Courts and help making it a success. We will have a chat with the panel for the next hour or so. And I think I'll introduce the panel. Tonight we have, at the far end, Magistrate Rose Falla. Her Honour is a proud Watchabalik, Wamba Wamba and Muddy Muddy woman. Magistrate Falla is the first Indigenous magistrate appointed in the state of Victoria and was appointed to the role of Supervising Magistrate for Koorie Justice in 2020. We also have Uncle Wally Harrison. Uncle Wally belongs to both his father's people, the Dja Dja Wurrung, and his mother's people, the Yorta Yorta and Wiradjuri. Uncle Wally was a founding member of the Dja Dja Wurrung Clan's Aboriginal Corporation, and in 2013 he started on the Victorian Koori Courts as an elder and respected community member with children's, magistrates and county courts. And lastly, we won't call her auntie. I've been told not to call her auntie. We have Terrie Stewart on the panel. Terrie is a proud Tanarong woman. Terrie is currently the manager of the County Koori Court, Court Services Victoria, and has worked in the Koori Court across Magistrates and County Court for over 20 years. So thank you. Right. So we might start off with you, Magistrate Falla. You were involved in the establishment of Koori Courts in Victoria. What was the motivation for establishing the court, and what makes it unique compared to the generous courts?
Well, the genesis of Koori Court really was, you touched upon it in your introduction, was from the Royal Commission into Aboriginal Deaths in Custody. That report and the 339 recommendations that came out of it really motivated community to work with the Victorian government of the day to create the very first Victorian Aboriginal Justice Agreement back in 2000. And contained within that was a motivation, an initiative to administer justice differently in a way that obviously still was within the realms of the law of this state, and but was fit for purpose for Koorie people. And we really, I was at that point in time finishing my law degree, and I had been an executive officer with the Regional Aboriginal Justice Advisory Committees for the metropolitan area, and was finishing, as I said, my law degree, and moved into the Legal Policy Unit of Justice, and had the very great honour of working with some real trailblazers, both in the legal system but within community, in creating the very first, what was a community-designed and community-led model as to what might be the best fit for our community. And it really was, it took us all over the country really to look at the Nunga Court in South Australia, in Port Adelaide, the Circle Sentencing Courts in New South Wales, and we took parts of those models and created our own. And we had our very first location. The community decided it was important to have both a regional location as part of the pilot program, and also a metropolitan site. So Shepparton was identified as the regional location, and Broadmeadows for the second location. And the first sitting took place in October in Shepparton in October 2002, and Broadmeadows in April 2003, and having our elders front and centre as we revere them as members of our community, but they are front and centre in assisting accused people having a cultural conversation, and the informality created in the court. And yeah, it's a pretty remarkable court, and it's truth-telling at its finest. It's front and centre. It's a difficult court to sit in, but it's an incredibly rewarding court. Absolutely.
Right. Uncle Wally, you're an elder on the Koori Courts. What's the role of an elder, and why is it so important?
I think the role of an elder is so important, but before I answer that, Amanda, can I just acknowledge if there's any Aboriginal or First Nations people in the audience? I'd like to acknowledge them. Who your family, where you're from. I'd like to pay respects to the Wurundjeri people as well as this country that we're on. I think culture is the most important part of the factor, is what we talk around the table, having that discussion around what are the cultural protocols that we use. And I think my role as an elder is to make sure that all the judges, the magistrates, the tip staff, the registrars, they're all culturally aware that the space that we're about to enter around that discussion around the table has got to be culturally safe to have that. So I think it's the role of an elder to establish that platform to work from, and that we get that in that discussion on that table, and I think that's the role of an elder. I enjoy it. When I first started, it was uncomfortable. I felt uncomfortable in that space because I normally sit at the back of the courtroom and watch or observe from, but to be at the table having that discussion is quite different. My background is that I've worked in family violence for many years before coming to the courts, and it was while coming to court I could see the value about the role that an elder plays, and I was asked to have a go at it. I was nominated by Rajak sit on a couple of court cases, and it's been a journey of about 8 years so far, and it's been one that's so rewarding, and I get to sit with another elder beside me, and we can both work together around making it a cultural safe conversation, not just for the defendant or the person that comes before us, but also for the magistrates.
Amanda, can I just jump in there to flow on from what Uncle Wally said? It's remiss of me, I've just assumed that people, because I sit in Koori Court so frequently, that people know what Koori Court is and how it's different. Yeah. I might explain, if you don't mind, what it is and how it is different from a plea hearing in court, and then it might be really helpful for Terrie from the county court perspective to talk about how they're different in our jurisdictions. So in order to be eligible to sit in Koori Court, in the Magistrates Court and the Children's Court, the person must meet the definition or meet the eligibility criteria that's set out in the Act, that they are an Aboriginal person, they identify as an Aboriginal person and are accepted as an Aboriginal person by the community of which they live. And it is, once the criteria is satisfied, and there is often plea material that is relied upon, the matters resolve as a plea. They're not offences that are prohibited, such as breaches of intervention orders in most locations other than Mildura, and sexual offences, then it is a matter that has resolved, it's a plea hearing, it's adjourned then into Koori Court. On the day of Koori Court, in the Magistrates Court and the Children's Court, there is a pre-court conference with the elders about the cases that are listed on the day, the type of offences that are listed. They've got the summaries and any criminal history, if any, exist, and often some of the materials that have been sent through by the defence solicitors. So it really does assist us in understanding the person's background. And most importantly, there's often information provided about who the person belongs to, where they can be placed in terms of the community, who their mob might be. And often it is very much a case where elders can actually connect the person to who their mob and their family, and know where they come from. We then, because it's derived from and taking on the recommendations from the Royal Commission and from the Justice Agreement and the creation of Koori Court, it is designed to be a very informal court setting. The courtroom itself is ceremonially smoked before opening and launching the courts, and periodically after that. There is an oval-shaped table, and that is deliberate. That is, there is no head of the table. Everyone is sitting around the table as a collective group. The magistrate and Terrie will talk about the judge, does not sit on the bench. They come down off the bench and sit at the bar table. We often have a possum skin cloak sitting on our table for people to derive a level of comfort from. There's often the flags also in the room, but there's also a lot of Aboriginal art that tells stories of the various people that have been through Koori Court, but also tell stories of the importance of our culture. It also, we have often symbols of Bunjil and our protector, our creation being, and our crow as well. So each location is around our state is different and have different symbols, and rivers are often important, and we recognise all of those too at the different communities. So we all sit around the bar table, we confirm the summaries, we confirm the charges, read the summaries, accept any prize if need be, and then we stop talking, and the solicitor then tells the elders a bit about the person, and then the magistrate, and that's my practice. I was taught by the founding magistrate of Koorie, as she was then, she was always Koorie. She was a magistrate for a period of time where she would push herself away from the table, just demonstrating that she no longer has a role to play. It's really the elders that are front and centre as part of that cultural conversation, and that's when that conversation that Uncle Wally talks about was certainly takes place.
Rich.
It is incredibly rich, but we do also really highlight for the protection of our elders that any sentence that is ultimately handed down is solely the decision of the magistrate. It's informed obviously by the material, it's informed by the person's participation in the court process and especially the conversation. But importantly, all sentences that come out of Koori Court are derived from the same sentencing act that is applicable to every person in the state of Victoria. So it's not a separate system of justice, it is from the same sentencing act using the same powers. Yeah.
Thanks.
Did you want to?
Oh, just to add, the county court, the county Koori Court is very similar to the magistrates' court. It's the process. The sentencing conversation is exactly the same, where the elders will talk directly with the participant before the court. But how we get to that sentencing conversation is a little bit different in the county court. It's a 3-tier process. So the first process, which is a formal arraignment, is very formal. It's where the judge will sit on the bench. He or she is robed. Defence counsel and prosecution are robed, and the participant or the accused person is sitting in the dock. It's where the charges are read out to them and they formally say whether they're guilty or not guilty. Obviously, when they're appearing in the county Koori Court, it is a plea of guilty only. If they don't plead guilty in the county court, it goes to a trial with the jury. So the first process of the arraignment is very formal. The elders aren't involved in that process, however, they are in the body of the court. They're observing, they're listening. Once that formal process has been finalised and the charges have been read out, the participant or the accused person has formally pleaded guilty, the matter is then stood down, the elders will meet the judge out the back. They'll get themselves ready. The court is then reconfigured into the bar table into a sentencing conversation. They then enter the room with the judge. By that time, it's a very informal process where the judge is not robed and neither is prosecution or defence. They're all sitting at the bar table. Once they reach the table, the bar table, the judge will then invite the participant down to the table. Once the person is sitting at the table, our judges will then do an acknowledgement to country. In some of our regional locations, if we have a traditional owner, they will obviously do a welcome to country in the courtroom, but we leave that up to the individual elders who are sitting on the day. So once the conversation has commenced, the judge has done the acknowledgement to country, everybody's then introduced. The elders introduce themselves. They generally say where they're from, and everybody else around the bar table is then introduces themselves. The Crown prosecutor will then read out what we call the Crown opening, which is the offences that have been committed. If there's any victim impact statements, the victim impact statements are read out, or if a victim's in the court and wants to read their victim impact statement, they're able to do that. They also have a voice in the county Koori Court. Once that process is over, then the judge then hands the courtroom over to the elders and the person who's appearing before that court. And that's a conversation that the elders have with the person who's appearing. They'll talk to them about who they are, about their family. They'll also talk to them about why they're there and the serious natures of the offences that they're committed, the impact that's had on the community, the victims, their family, and in particular the Aboriginal community in general. It's a powerful conversation. Each elder brings their own cultural knowledge and strength to the conversation. We generally have 2 elders that sit and speak to the person who's appearing, and that conversation can take anywhere up to an hour to an hour and a half. It is intensive. It's very powerful. Victims, I've mentioned before, do have an opportunity to speak in the court, and some do. Some prefer to have the prosecution read out their victim impact statement. But the elders will always acknowledge the victim. If they know that they're in the court, they'll acknowledge their pain and suffering. Following that, it can go on for quite a long time and very intensive. Once the conversation has finished, the matter's then stood down. The judge will then ask, in the county court, I must say, prosecution and defence must submit what they want to see happen to the person who's appearing before the court. It must all be in writing. So defence submissions and prosecution submissions. It is a requirement when for prosecution and defence to submit their submissions. The judge may ask a few questions to elicit some information out, but they generally will sit back and listen to that conversation. Once the conversation is complete, the matter is then stood down. It finalises the sentencing conversation and the elders' part in the process. The next process, like I said, it's a three-tier process, is the sentence. Now, in the county court, due to the nature of the offences that we hear in the county court, and we hear very serious offences, most people who appear in the county court are in custody and will, in many cases, will remain in custody following the county Koori Court sentencing conversation. So the sentence that is handed down, and like Magistrate Falla said before, the judge makes it very clear to the people, the person who's appearing before the court and any of their support people, that the decision that is made is his or her decision only, that the elders have no input into this decision that is handed down. That is made very clear to the person who's appearing before the court. The sentence in the county court, as opposed to a magistrate's court hearing, where they probably will sentence on the same day, in the county court, due to the serious nature of the offences, the material that needs to be, the complexities of the person who's appearing before the court, and the material and all the legal stuff the judge has to take into account, it's very, very rare that the judge will sentence on the same day as a county Koori Court hearing. It's generally a couple of days later, it could be a couple of weeks later. There might be some more reports that the judge may require. But the elders aren't involved at any way in the sentencing hearing. But however, once the sentence is handed down, we will always let the elders who have sat know what the outcome is. And in the county court, when a judge hands down their sentence, it must be written, and it's quite lengthy sentencing remarks that the judge must abide by in the court. So once those sentencing remarks are available, we do send them out to the elders as well. So yeah, that's a little bit about the difference between the magistrates court and the county court. But obviously, in the county court, the offences are far more serious and carry heavier penalties. So.
Right. This question's for you, Your Honour. The magistrates and justices obviously rotate between the generalist courts and Koori Court. Do you think their experiences in Koori Court influence them in the genuine courts?
Yeah, certainly I do. Clearly, the way in which we approach Koori Court falls within our specialist courts and programs section, and we're applying obviously the principles often of therapeutic jurisprudence, and the lessons that magistrates who sit in Koori Court learn, and that's often through the conversation they have with the elders and learn so much about culture, in addition to the education that's provided to them both internally within our court but also through the Judicial College, and that certainly since its creation in 2001, but certainly more recently as well, there's been a comprehensive piece of work done with the Judicial College in educating judicial officers. But certainly in our court, it is really important that people understand what the judicial officers understand Koori culture, sorry business, cultural practices, what intergenerational trauma is, meaning the complexities that families are dealing with on a daily basis, understanding cultural loads, what lateral violence might mean within community. And it really does, when people understand too, and the magistrates and judicial officers are understanding the services that are being offered by Aboriginal community controlled organisations and actually referring to them by name, you can actually see the accused person demeanour completely change, because it really they feel as though, oh, they know about Bundawarra or Wimpachur or some of these organisations, that instantly it's like, well, they're talking a language I understand, and there's comfort in having people know that that rehabilitative service is designed by Koori people for Koori people, and that allays some of the concerns that has. We, since I've come into this role and since our Chief Magistrate became our Chief, it was really identified that for induction, as an induction process for new magistrates, that there be a component of cultural awareness program done from specifically from the Magistrates Court of Victoria's perspective. The Judicial College do a broader piece, but we needed to, obviously, because of the work we do and the variety of the work that we do, that there was a need to help people better understand, or first get an understanding of what their cultural knowledge might have been, and then enhance that. And everyone that's gone through that process has. I've been buoyed, I have to say, because they're coming in with a lot of already existing knowledge that really does lift my spirits, I have to say. Yeah. Absolutely.
Right. Uncle Wally, elders provide that cultural accountability in the court space, but some people think that going to Koori Court is the easy option for offenders. Can you speak about how Koori Court actually make our people take a higher level of responsibility? And what are some of the things you typically want a person to think about when they come to Koori Court?
It's a good question again, Amanda. I think for Aboriginal people who come to court, it's one of the hardest things they'll ever do in their lives. The amount of shame that they feel when they come before us about not just letting themselves down, but letting their families down, their cousins, the mob down. It's that shame of disconnection about it. So what are the impacts of that to them when they come before us? It's about establishing that conversation around, hey, it's all right to feel that way. It's the understanding of the intergenerational trauma about Aboriginal people and how they feel when they come to court. It's our role as an elder to get to their level and get the understanding that, hey, there's accountability for what you've done, but there's reasons why you're here today, and who's your family, where you're from, and tell us a little bit about yourself. And knowing that the courtroom's been smoked, what happens when the smoke goes up to the sky? It's a chance for you to go with that smoke and talk to your elders up there. I always mention that to the court and let them know that you're being watched and you're being cared for. Once you establish that connection, the conversation then flows. But you're right, Amanda, there is accountability for what they've done. The matters that come before the county court are quite serious, and that comes with accountability for what they've done. Even at magistrates' courts, there's the simple things like stealing someone's car. It might be a family with 4 or 5 children. They haven't got a car. They've got to walk down to the milk bar to get the milk and bread. Those sort of things. Those little conversations around the table just opens up that, gets them thinking about the impacts of what they've done. I enjoy those conversations, and they need to happen. That's probably... there's many other scenarios about what can be delivered around that table in that conversation. Cultural-wise, not all people that come to our courts are from Victoria. They might be from Western Australia, so they could be from another nation like Wungai or Namadgi people. They could be from New South Wales, Wiradjuri. So I think we have to establish that we are Aboriginal people and we're families of families. So when they come into they've got a responsibility towards us you've mucked up on our country, and we want you to be accountable to us, and we want you to apologise to the elders of this community today and say sorry for what you've done. So accountability is so prominent within the structure of the Koori Court.
Yeah. So, Terrie, this one's for you, and you've been involved in the Koori Courts for a long time. What impact do you think the court has had on Aboriginal people who come through it? And do you have any favourite success stories of people who have been through Koori Court?
Yeah, absolutely. I mean, the impact that has on Aboriginal people, my experience over the last 20 years and working in 2 different jurisdictions has been enormous. I think over those 20 years I've seen a shift. When I first started in courts, there was not a lot of knowledge about Aboriginal people, culture and history, but over those 20 years that has changed. I know Magistrate Falla talked about Aboriginal cultural awareness training. In the county court, we hold Aboriginal cultural awareness training for judges. So judges who sit in the county Koori Court need to have participated in Aboriginal cultural awareness training and ongoing Aboriginal cultural awareness training. We also, when we sit in regional locations, so in the county court, when we sit in regional locations, we sit what we call on circuit. So there's a month-long criminal circuit. 2 days of those criminal circuits are for county Koori Court sittings if required. So while we're in those regional locations, we like to arrange for our judges to visit our Aboriginal organisations, if there's any rehabilitation centres in those particular regions, Aboriginal organisations, meet with program managers, so they've got a better idea when we talk about our Koori programs in communities, that they have an idea of what we're talking about. In saying that has had a great impact on and a better understanding of the person who's actually appearing before the court. So the impact has been enormous. We have judges now who don't sit in Koori Court, or who may be sitting on a matter that's not eligible to come in Koori Court, that are calling upon us as Aboriginal people for cultural advice. So that has had a big impact as well. So.
Great.
Amanda, could I just add something else to that? It sort of dovetails into the question that you asked me just before as well. Anyone who says that Koori Court's a soft option or an easy option has never sat in Koori Court, because when you see and how heartfelt, how genuine how remorseful and how willing people are to address the underlying causes of their offending, they I think very quickly proven wrong. Court of Appeal have also identified that not relying upon your counsel to put the plea on your behalf, but actually speak to the reasons why you're offending, and speaking to our elders is very onerous and ought to be considered as another mitigatory factor in terms of the plea. But I wanted to also mention, when you asked the question about how Koori Court is influenced, I have one of my wonderful friends and colleagues who have not sat in Koori Court, but been influenced by obviously a lot of the training that's been offered, and has had a Koori person in our bail remand court who has decided not to come up, not to participate in the court proceedings that is about them, because in their mind it's a foregone conclusion that they'll be remanded. And because she's a beautiful person who is very committed to recognising and doing her job so well, she's coaxed the person to say, would you mind just coming up so I can have a chat to you? And then as it's proceeded, it's melted away the concerns that person has had, the concerns have been dissipated, they've been able to run a formal bail application. So it is permeating, and that education and willingness by judicial officers to learn more, to be open to and really try and encourage people to not just see things as a foregone conclusion. And it's a real credit to her and also to my colleagues that across all jurisdictions that are willing to do that.
Obviously we're here to talk about County Koori Court or Koori Court today, but my team also assists in the Supreme Court bail applications. So that's when a person may be knocked back for bail in the Magistrates Court, they then can appeal that to the Supreme Court. And we've seen some real success in bail applications getting up in that jurisdiction by simply providing the lawyers with information about programs and services that can support that person in the community. And I'll talk about one case in particular where this person was lucky enough to get bail. He was from a regional location. We were able to link him into drug and alcohol treatments, a men's behavioural change, a men's shed program. And when his matter was finally went before the court, he had been doing very well and had been participating all the programs that were set up for him. And he probably was looking at a jail term, but because he had done so well, he was able to be placed on a community-based order. And from all reports, he's been going good guns from the time he was placed on that. And I think he's successfully completed that community corrections order. So those are the things that probably didn't happen 20 years ago or 10 years ago. But the judicial officers are now asking us as Aboriginal people, and there's lots of Aboriginal people work within court services, Victoria, in a variety of different roles, that all can provide cultural advice to the judiciary on what programs and services are available to support our mob out in the community. So,
Great. Magistrate Falla, the Koori Court centres on sentencing. What does that mean? Who's involved and why is it important?
So the sentencing conversation takes place as we've described, and it really is, applying all the sentencing principles that Marston. And as Terrie's indicated, not all cases are finalised on the day. Certainly there is, and we do in the Magistrates Court, have people in custody, and they may stay in custody depending on the seriousness of the offending. Sometimes they are bailed, and it might be to participate in programs, and that's just not something that happens willy-nilly. There's usually a planned transition back into community, into rehabilitation. So there can be a deferral of sentence. If it's obviously at a lower end where it's, it might be a first offence, driving while suspended, you're going to finalise those matters pretty quickly. But it's often, we talk about, as Uncle Wally has said, about, the value of a person's car, and if you're disqualified, it might be impounded, the family's without the car for a month, what that then means, the cost of getting that out with the cost of living, all of those factors, and what that then means particularly if it was auntie's car and not, or nan's car and not the person's car, that flow-on effect. So it can be finalised on the day. Sometimes there is a deferral. As I've indicated, there is, back in the day when we were creating Koori Court, it was very clearly identified that some of the offences can be very serious in our jurisdictions, and we wanted it to be clear that the elders didn't have a role to play in the sentencing, not that we didn't think that it was appropriate that they did, but more importantly to also ensure there's no backlash within community by exposing the elders to them somehow being involved in that decision. So as judicial officers, it is our role to finalise the sentence based according to law, balancing all of the sentencing principles that we must, and obviously give people the opportunity of driving their own outcomes to their own rehabilitation. But as Terrie touched upon earlier, victims also have a role to play in our court, and I have sat and I do sit in the Children's Koori Court. Obviously, sentencing in the Children's Koori Court is very different. It is governed not by the Sentencing Act but the Children, Youth and Families Act, and obviously the primary focus there is on the child's rehabilitation, and it is in line with our topic of, for our elders, it is the most in all of our jurisdictions, but certainly in our Children's Court, seeing the elders interact with our young ones is really very special to see.
Yeah. Uncle Wally, when you think about the protocols and the processes that embed culture in the Koori Court model, how do you think that could be expanded to other parts of the legal system?
I think it's, we talk about culture, Amanda, it's law, L-O-R-E, and law, and there's a difference in the two. Which one do we use in the court model? The protocols have got to be that way. It's got to be based around identity, about knowing that person, how they identify, and getting to know what their preferred story is, where they're from, and what they know about their culture. A lot of Aboriginal people are from a stolen generation and don't know, or know very little about themselves. So we spend time around that discussion. It needs to happen. You have to build that rapport. So we need to understand what's the best outcome for them in that discussion around how do we hold them accountable, and how courts can make that accountability flow right across. It's got to start from the Children's Court right up through the magistrates to the county, and one day we'll be in the Supreme Court, I reckon, somehow. It'd be great if we were there, but I think we have a role to play in that preferred story of Aboriginal people, of why they're offending, and get to know how we can support them better.
Great. Terrie, over the last 5 years there's been a number of Koori Courts opened in regional locations. Why is it important to have local Koori Courts?
Well, it's access to culturally specific justice for all Aboriginal people across the state, so that's really, really important. It's their cultural right to be able to appear before a Koori Court, regardless of which jurisdiction it is. We've seen over the last 10 years in the county court, our first county Koori Court was a pilot program in Latrobe Valley. Since that time, we've expanded to over now 7 locations with an expansion plan to the Bendigo region at the end of this month. So it's about access to culturally specific justice for all Aboriginal people in Victoria. So.
Great. So the next two questions is for all the panel members. And the Victorian Government is about to start negotiating treaty with the First Peoples Assembly of Victoria. Do you have any thoughts on how treaty could create change in Victoria's legal system? So I might start with you, Terrie.
I might.
I'm not sure what the answer is.
Yeah.
Amanda, I remember when the treaty was first brought out to me to have a discussion around it, and I tried to get my head around what treaty meant for us and what's the purpose of it. And I go back to the days when we started Jar around, 15, 20 years ago. There's a facility on my country, Malmesbury Youth Centre, and they did an extension on it without letting us know. They did the extension on it, and they knew they offended, so they come to our corporation and said, how can we make amends? How much money would you like? And I said to them, we don't want any money. We would like you to employ 2 Aboriginal young people, but we don't want them to be prison guards. We want them to go up into higher management. And we did. We got that. We got 2 people. And one of them's a BPS 4 now. I don't know what level that is. But they've managed to get themselves up. So treaty is about having that conversation about self-determination, about how we can get there. And for me to sort of, that's what treaty is all about. We want the best outcome for our families. And it's not all about money. It's got nothing to do with it. It's about housing and a better life. So if you look at Aboriginal people today, when they come before us, we're overrepresented in the courts. We're overrepresented in childcare, removal, the highest rates of children going into out-of-home care. Where do they go after out-of-home care? They go into resi care. They go into institutions after that. And then they end up coming before us at court. So what happens when they come before us at court? We see those same people again and again, even when we're walking down the street of a Saturday afternoon. They'll come up and say, how you going on? I'm doing really well. I haven't re-offended. It's been 4 years. I said, well done, well done. It makes me feel good. It just justifies the work that we do. So self-determination towards treaty and the voice it's got to happen.
I mean, what I'd like to see happen is, we have over 100 Aboriginal staff members that work throughout Court Services Victoria now. We have 2 judicial officers. In the Magistrates Court, we need more Aboriginal judicial officers. And there's a lot of Aboriginal people out there who have studied law, who are practising. I'd like to see more Aboriginal people being appointed to not only to the Magistrates Court, but to the County Court and eventually the Supreme Court. They're in a better place. Aboriginal people are in a better place to understand us as Aboriginal people, the intergenerational trauma that still exists in this country, and it does affect our people every day. So that's what I'd like to see.
Good.
Something Uncle Wally said was touched upon self-determination, and I only mentioned this in a meeting with my colleagues not so long ago about what self-determination means, and really it's achieving greater prominence now, but it's always existed for us. People are talking about it now as it's something new. It's not. And Koori Court, I suppose, is an example of self-determination in action, and that's been going for 20 years. We've always identified that there shouldn't be anything for us without us, and that's what we recognised way back then, in that this was a community-designed court in conjunction, obviously, with the courts in creating it. But it really is important about when you hear and listen to the voices of Aboriginal people, the outcomes are better. And you talked, one of your questions earlier was about the ethos of Koori Court and how it might permeate other lists. And self-determination has created Koori Court. The way in which we do Koori Court has really created, and I'll be so bold to say for our colleagues, our brothers and sisters of Maori descent across the ditch have created the Rangitangi courts based upon our Koori courts, and we've had the great privilege of going and being on the marae to witness that firsthand. But it's also informed the creation of Maramagala Gambu and the Children's Court in the Family Division, and that is having Aboriginal families wanting to move into the catchment area to be able to participate in that court. Now, that is something that absolutely it should be, bells and whistles proving that and it's been evaluated as being highly successful, and it's been rolled out now in Shepparton as well. So you've got Koori families sitting around a table with a magistrate in family, child protection, family division matters, and really driving their outcomes, having their voices elevated and listened to. So it is traversing all of our lists in identifying that when you hear from the Koori community about what is going to work, it works. So it really, that's part of the self-determination plan that CSV has rolled out, that we, as all of the jurisdictions, all the courts, including VCAT as well, have all committed to, and that's where I see the real change is going to benefit our communities.
Yep. Are there any other aspects of traditional Aboriginal governance and knowledge models that should be a part of a transformed legal system in Victoria?
Well, that's stumped us, hasn't it? Look, I'm always open to... I don't hold the answers. I'm just one person. But I think in our system, with our structures in the way in which we work, and as a community, when someone does come forward with an idea, it's like, well, what's that going to look like? How do you see that working? How do you see the role for the elders or not necessarily elders, but younger people? And for example, we've just had a discussion about our drug court, and I know the county court have a drug court as well, about how we could have, at the milestones and the graduation processes from the phases, how there could be ceremony involved in that from a cultural perspective to keep Koori people going through that process and, reward culturally and enrich that person and a greater level of confidence in them about how they might, to keep them on track to graduate through the next phases and then ultimately through the program. So there's always ways in which we might be able to have culture added into our court lists. In terms of the transferring of into legal, what the legal system might look like, let's give it a go. Bring up the ideas, let's talk about them, let's brainstorm about how that might work, might not work, and if you can trial something, we should give it a go if everything aligns and we can get it happening. Not sure I answered that entirely, but I gave it a go.
Just thinking, Amanda, I've
feel like
come from a
Uncle Wally
family
wants to say
violence
something.
background, and I know the value about working with men that use violence and how we can better assist families around that space. We don't hear family violence matters in our courts. It's not culturally appropriate, but I'd like to see that platform come in some form, just to stop it from happening.
Can I
That's
jump
my
into
view.
that?
Yeah,
That's something certainly we're looking to roll out, because we have had the pilot in Mildura about the breaches of intervention orders being dealt with in our courts, and I think the Aboriginal Justice Caucus that is part of the Aboriginal Justice Forum has identified that yes, you could do that, but you need to have the safeguards in place for all participants in that court to ensure that it's a safe place but also a culturally safe place. So certainly that's something we're looking looking at doing. But you raised a really good point, and part of the training that I do with some of our colleagues about family violence and training is that family violence often, and I think there's a myth that I want to dispel, is that family violence is always perpetrated by Aboriginal men against Aboriginal women. It is not. A lot of the statistics do show that it is not Aboriginal men committing family violence against Aboriginal women, but clearly there is obviously a cohort of our men that do. There is also not so long ago, there was an article or a cartoon published in The Australian many years ago about being a derogatory cartoon about Aboriginal dads or Indigenous dads, and it created a wave on social media of hashtag Indigenous dads. And Thomas Mayo, who's been very prominent in the Voice campaign, created a book called Dear Son, and I would really encourage you to get a copy of it. It's a really beautiful book insofar as it's got many prominent Aboriginal men and Torres Strait Islander men across the country that have penned letters to their sons about, and one of them particularly talks about family violence, that it's never been our way. It's not our way. We respect our women. We hold them in high esteem. You know, I couldn't love your mother any more than I do today than I did when I first met her. And it's Troy Cassadaly, Stan Grant, some really prominent Aboriginal men have written this book, and it's really beautiful, and it absolutely dispels those myths that you talked of, Uncle. Yeah.
Anything
else, Uncle Wally? I see your mind ticking away.
It is a great conversation.
Yeah.
210, 20 years ago, family violence was never heard. There's never even a word back in those days. Not like it is today. We just need to go back to the old ways.
Well, we've come to the end of the panel now, and I would like to thank our amazing panellists, Magistrate, Falla, Uncle Wally and Terrie. I'd like to thank the Wheeler Centre for putting the event on, and thank you to everyone for coming tonight.